I'd like to thank you all for coming to Miller Thomson's latest edition of Corporate Counsel CPD program. Today we're going to be dealing with the workplace investigations, and Nicole Byres, our head of our Vancouver Labour and Employment Group, is going to give you some tips and do's and don'ts, practice tips to help you when a workplace investigation happens. Nicole is, as I mentioned, the head of our Labour and Employment Group. She's Vancouver based and is probably one of the most experienced labor lawyers I've ever come across, and also from a practical perspective has a long career as corporate counsel, and has probably attacked a lot of things and faced a lot of challenges similar to what you would all have faced in your careers. So I'm going to pass this over to Nicole. She's appeared before numerous tribunals and courts in BC on various issues, including workplace investigations, so I don't think there's anybody better qualified to talk about this. Thank you very much.
Good morning. Thank you very much for attending both on the webinar and in person here. I appreciate it. We're just going to dive right in. It's a fast-paced hour presentation, or just slightly under an hour. The materials that you have, some of the slides I'll go over very quickly, but the materials are, I think, can be used more or less as a checklist of what to review when you're doing a workplace investigation. And so if during the presentation I've gone too quickly or you don't quite get something that I've been explaining, please, at the end of the materials, you'll see my contact information as well as the contact information of the group, the Labour and Employment Group here in Vancouver. Any one of us would be very happy to answer any of your questions. And with respect to that, one of the members of the group is in the rooms, Ashley Mitchell. She's here today by the wall here. So the presentation is set up as preparing for the investigation, conducting, and after the investigation. So there are many reasons why you may, as in-house counsel, may need to do an investigation, from workplace safety incidents to bullying and harassment. There's some statutory requirements also besides WorkSafe BC is you could have safety issues, environmental issues. You have an accident at the plant, for example. So, and protection of assets, meaning, you know, maybe there's been a theft of property or some type of malfeasance in terms of a business opportunity that somebody has, you suspect at least somebody has taken from the company. Preparing for the investigation is very important, and I can't emphasize that enough. And that's because it lays the foundation for everything that you do. And it sounds a bit trite, but you lay if you lay the preparation down or get that right, chances are you will accomplish the objectives, at least of what you're looking for. Choosing the investigator is one of the first steps. You don't have to have somebody legally trained to do the investigation. It can be an HR person, it could be a psychologist. I've hired psychologists who are also trained in investigations for workplace bullying and harassment situations where I wasn't quite sure what was going on, but we knew we had a workplace with some dysfunction going on and some problems. Impartiality is really important, and it doesn't necessarily mean that internal versus, you know, it has to be external all the time. It can be an internal. Sometimes, but you can have people that are in your organization, but just maybe in a different location, a different department, somebody who doesn't necessarily have all those personal relationships with the people that you're going to be interviewing, because that can be sometimes a challenge in terms of the information you get. You should consider whether or not it's important that the information be privileged or not. This has to do with, you know, if you think there's a possibility of other legal consequences, like some charges, prosecutions under whether it's the Workers' Compensation Act or some environmental statutes, you may want to have privilege. Otherwise, in many of the workplace incidents, probably the majority of them you would not. That's a conscious decision depending on what you want to use the information for, or what you think might be lurking as a result of the investigation. Defining the scope and the purpose, again, sounds simple, but it is pretty important to be focused on what it is you want to do, because there is an opportunity in investigations for the scope to change and shift, and you want to be really clear as you're getting new information in what it is that you want to accomplish. There could be all kinds of things, whether it's a specific complaint or an incident that you're investigating, or something more systemic. And as I mentioned, in my workplace harassment, where I'd hired a psychologist, we weren't quite sure, other than we had some people leaving and complaining about less specific issues going on. There can be reputational issues to your organization also, and so that will define whether or not you want to have something low-key or very quick and precise. You may have some urgent or emerging public relations and communications issues you think might flow from the results of this investigation. Again, you want to be really clear on whether that's within the scope of the investigator or not. When you're thinking about or planning your investigation, the evidence that you will be collecting, you want to think about where you're going to do that. Are you going to be taking notes? Who is going to be there to assist with the gathering of the information? There's going to be paper, or often there's paper and electronic evidence that has to be secured. And do you have the right resources for that? So for example, if you've got information on a bullying situation, often now you get some of that information going on through texting, through personal PDAs, as well as workplace supplied equipment. And so you need to be able to think about or think ahead about where that information might be, as well as then planning your strategy for securing that information so it doesn't disappear once people find out there is an investigation going. Privacy and confidentiality is a really important issue also. As you all know, there are both two sets of legislation in the province for the public sector as well as the private sector on protecting privacy. Most employees nowadays know about their rights with respect to their personal information. And besides the privacy issues, there is nothing more disruptive to a workplace than gossip about an event and the investigation. And so you want to try to manage that as best you can. The location of where you're doing the interview, for example, can be one of your strategies for protecting confidentiality. Maybe it's not in the main work site where everybody is. Maybe you've need to do it in a separate place. You want to determine who in advance has access to that information also. In looking and planning your investigation, you will have to identify your witnesses. And you want to be, as the slide says, you want enough witnesses to get the facts that you need to get to, but not too many so as to completely disrupt your operations. And it's a little bit of a fine balancing act sometimes. And of course, you do need to be flexible, because inevitably, as you're interviewing, you will probably learn things you didn't know before in terms of possible sources of evidence. And so you want to build in that flexibility to expand if you need to. So for example, if you're putting a mandate together for your investigator and you say you've got 3 or 4 witnesses, be conscious that you may have to amend that. So the investigator comes to you and says, I've uncovered that in my investigation, several other people know about this. I'd like to go ask them. And again, you make that as a conscious choice, but the flexibility is really important. The timeline and schedule is very much part of your planning, and The availability of witnesses, the scheduling of witnesses, gathering of information can be tricky at times depending on where people are in your organization. The issues that you may have identified at the beginning of the investigation, sometimes you might also have to add to those. Just as you might add witnesses as you learn more information, you may find that there was an underlying root or cause of the particular incident that it didn't occur to you, or a peripheral risk that was identified in your investigation, and then you want to consider whether or not you will want to expand the scope of that investigation or park that information because it's not material to the initial purpose, but it's something you want to follow up on later, just from, for example, a risk management perspective. Once you've planned your investigation, then you get into the next phase, of course, which is conducting the investigation. I do recommend two people be present while you're interviewing people. That is just, you've got somebody to do the recording and some recording, whether it's, notes usually. But the other person can be, pay attention to the witness in the questions that you're asking. You want to look at their demeanor and all those other things you do when you're assessing credibility. And you also want the flexibility to be able to move slightly off topic as the questions lead you. By all means, you want to, and I'll talk about this a little bit later about planning your questions, you do need a bit of an outline in a script, but it is very helpful if you're not the person asking and taking notes at the same time. Objectivity is, as I mentioned earlier, really important, and sometimes there's a tendency, human nature, we're so quick to judge. We do this all the time, and even trained investigators. And so whether you have a trained investigator or someone in your organization, it's really important that that person be able to stay a little bit removed from the information they're gathering until the process is over. Certainly pre-jumping or jumping to conclusions or prejudging is one of the things that happens frequently that get employers particularly in trouble when they then act on information prematurely, maybe terminate somebody or move somebody, and find out when that person who is affected by that decision fights it or challenges it that they don't actually have good evidence to support it. It sounds, again, one of those obvious things, but surprisingly how many people or how many organizations or clients I've had where they do an investigation but don't ask the individual who's at the core or the center of the complaint what happened for their version of the events. So I've had people say, well, it's so obvious that X, Y, and Z happened, we don't need to talk to that person. But there's many reasons for doing so. One, you might just get some information you didn't anticipate, which is, well, my supervisor told me to do it, or we've been doing this for years. That type of information you want to know about. But it also gives the person the opportunity to be heard, because fairness is one of those things that particularly courts and tribunals look at when they're assessing whether you've terminated, if that was one of the results, or disciplined somebody properly, was whether your process was fair. And they want to say, well, if you didn't give the accused, for lack of a better word, a chance to explain themselves, then how could that process have been fair? So you don't want to just prejudice right off the bat the appearance of fairness in your investigation. You're going to, as I mentioned, be gathering information from other sources, and this is where it's usually really helpful to have somebody who knows what they're doing. If you have an IT department, great. If you don't, hiring somebody externally to preserve evidence, to record it. Besides the fact that they know what they're doing and can't inadvertently mess up the metadata or some of the other things that we worry about as lawyers from an evidence point of view, it also helps with respect to the privacy issue. So for example, if you're suspecting somebody's texting on their own, on a on a cell phone or a smartphone, whether or not you as an employer provided it or not, that phone usually also has a lot of private information and personal information. Having a third party or an IT person to look at that, to scan it for the issues you're concerned about, often will alleviate some of the concerns with privacy. So it's not your boss or somebody, a coworker who's looking at perhaps personal things as well as the other things. You've got somebody who is an IT department person or an external person who has a very narrow mandate to scan only for certain things. They don't care about anything else, and it helps you get that permission, if you like, for those personal hand devices, and it also helps with respect to alleviating any other complaints with respect to privacy. The interview questions, it does take some preparation. For sure, you're going to want to do some pre-planning. I always do have a pre-plan, and as some of my associates learned last week, don't always stick to my plan, but at least it's a place to start, and because or a place to go back to if you do get off track with something interesting that you learned or the investigator learned at the time. The detailed notes of the investigation is important, as well as preserving that information. You never know where the investigation is going to go after this, and when you might need that to produce those types of notes. They are relevant, they are producible, unless you've hired a lawyer specifically for a privileged investigation. And so you want to be able to have access and record that information. As mentioned in this checklist here, it talks about recording the names, the time, the date when you interviewed the person. That's all relevant information. I don't know how many times when I've gone through somebody's investigation notes and I'm looking at something and I can't tell when the interview occurred. And sometimes it can be a year or two later. And that can be relevant in terms of timelines and when certain things unfolded. I would like to know if somebody was interviewed a few hours or a day after an event or 3 months after an event. That certainly will affect the recollection, and I want to know ahead of time if there might be some possible issues with the memory of that witness, because you can bet they're going to come up if that matter is being contested later on. Providing copies to witnesses to read and confirm is a practice that if you're pretty sure that this is going to potentially result in a hearing or at least something serious, you want to make sure that you've recorded your notes correctly of a witness. And so it doesn't hurt to, after your interview, you've recorded that in some type of documentary form, go back, meet with the witness again, and ask them to read it over and make sure that you've accurately recorded what they've said. And if they say yes, it's fine, get them to sign it and date it. Because, again, it may be a couple of years later you need to refer to that, or the memory of somebody may be completely gone in terms of those events that they had, and you want to be able to say, well, this was your statement, you signed off on this saying that this is what happened. It's much easier to pin that witness down to a statement they've signed off on and said it was accurate than something that you didn't. As I mentioned, there are some duties that companies have, particularly employers, in their investigations, and there are a number of cases now, both in British Columbia and across Canada, that have said that if investigations are flawed, the employer particularly has breached their duty of good faith. And so they've got an obligation to fairly investigate incidents. And if you terminate somebody particularly, and based on a flawed investigation, and you're wrong on the decision, not only you're liable for those damages for a wrongful dismissal, you also set yourself up for aggravated damages for that bad faith and for not conducting that investigation fairly. So if at the end of the day, and you're lucky, you have a flawed investigation and you win, and you did have enough evidence, the fact that you had a flawed investigation is not going to lead to damages. But if you've got a flawed investigation, I would argue that your chances of winning are much less if you haven't gathered the right information. So now that we've got your investigation, you've gathered your evidence, there's what do you do with that? And there are some steps that we would recommend that everyone follow in terms of wrapping this up. So first of all, assessing credibility of your witnesses is one of the important issues. It's really hard to tell if somebody is lying. Unfortunately, there are some people who are really good at it, and I've been fooled a number of times. And the best way that I've found that, at least personally, I've been able to distinguish whether or not somebody was telling the truth or not is paying attention to the details of their evidence and then comparing that evidence to other people's evidence. It's usually, when people aren't being truthful, it's usually the details that catch them. And so they can be very good presenter and very confident, but they will, they fall down on the details. And that's usually where you get clues that this person just isn't credible. Does the story make sense? Does it conflict with other witnesses' stories? Is there physical evidence or documents that will challenge that? And so, for example, if you've got somebody who you suspect of some wrongdoing, you may have one interview with them where you gather their story, and then you continue and complete your investigation. You may need a second interview with that person where you then put some very pointed questions to them, where you say, we've done this interview, we've discovered this, this, and this. What do you have to say to that? You may not have had that the first time you do the investigation, and so it's not uncommon to have some of the main players investigate, part of an interview more than once, depending on what it is you've discovered later on. When you're looking at the evidence, you want to determine whether or not the story, if you like, is being supported by all of the facts. Is a complaint substantiated or not? Sometimes, unfortunately, your investigation will not be conclusive. You will not be able to demonstrate on what we call the balance of probabilities. Is it more likely that something happened or not? And sometimes you may get sufficient conflicting evidence that you're not able to determine that this individual, for example, did this. And in that situation, you want to be sure, again, there's a tendency when you do investigation, you want to get somebody, you want to wrap it up in a nice, neat bow and say, we've done it and we've got this result. You may find that you don't get that nice, neat package. And so it's very important that you recognize that. There may be lots of steps you can take to prevent future occurrences and to mitigate risk, but you may not be able to actually definitively answer what happened. We're working on a WorkSafe issue right now where a piece of equipment was turned on and a worker injured her hand. And we still don't know who turned the machine on. And so despite the investigation, and so we're dealing with WorkSafe with respect to that, dealing with all of the other things around that, but we have not been able to find out who turned a machine on that ended up with somebody's hand. Probably somebody's protecting somebody, but in this large workplace, nobody's saying, I did it, I turned on the machine that resulted in this injury. It happens. So as I mentioned, sometimes things don't come together in a nice, neat bow. You want to look at, if your evidence is inconclusive, maybe there are other avenues you can go down to investigate to fill in those gaps. But, it goes without saying, don't take steps unless you're sure, the balance of probabilities at least. There may be things that you do from a risk management point of view. I know many of you in your positions, you're managing risk all the time. you are making business decisions or helping your organization make business decisions where you are balancing a risk of you're managing it as best you can, but in a way that allows the business prudently and legally to go forward. And that is no different with respect to your investigation. You may find that you don't have a conclusion, but there are things you can do to manage risk of future occurrences. One of the things that come out often with bullying and harassment complaints, for example, is you identify a need for training. You might have thought you did a good job with your harassment training and your policies are clear. Lo and behold, you start an investigation and you get a few employees who are saying, "What policy is that?" Or where you were pretty sure they knew about it. That's usually a wake-up call to do some more training. And I had one client where it's exactly that happened. It was a harassment. They had a very good policy. They had what I thought were good training processes, and inexplicably we got a group of employees involved in some basically it's a form of cyberbullying where something from one employee's past showed up on a video, and it was passed around by these employees who knew perfectly well, or should have known perfectly well, that was a problem. And so we went in and the client went in and retrained everybody, including their managers, with respect to that behavior. If your evidence is inconclusive, you do have a challenge with respect to the person who perhaps laid the complaint to begin with. They will be expecting the results. They will be expecting some consequences for what they say happened. And it is a very tough conversation to have sometimes when you say that, we took your complaint seriously, we investigated it, we looked at a number of this, we just, have too many conflicting evidence. I guess the evidence is conflicting. We can't come to a conclusion. Sorry about that. Sometimes that happens. Employees aren't happy about that, but it's far better to give the news to an employee about that than go and to make them happy, take some action that's not justified on the evidence. There will usually be a final report summary, something that the investigator will pull together in order for the decision makers to make some decisions as to consequences or risk management issues coming up. The report is an important document. I wouldn't skip that step because it allows the parties to document what they base their decision on. Sounds, again, one of those obvious things, but if you have a bunch of witness statements and a bunch of documents, you're going to want to piece it together in a story and point out what were the most compelling reasons that led you to a particular conclusion. Again, at the end of the day, although you want to be right, it's the process that's very important. And you have if you can demonstrate some integrity to your process, that you gathered the evidence, you considered all the relevant factors, and you've documented that, that will withstand a lot of scrutiny, and that will withstand a lot of challenges with respect to that you might down the road, whether it was incomplete or not. Thanks, Charlie. We've got an unexpected visit from some of our other offices that we're going to turn off. Now, there will be people who have laid a complaint who will obviously want to know the results. You also have witnesses who will be very interested in knowing what the result. Those witnesses do not have the right to know necessarily. Again, you may have privacy issues. And so one of the questions that often comes up in investigations is, well, am I going to know what the result was? Sometimes it might be obvious, and sometimes it might just be no. Sorry, for confidentiality reasons, you're not going to know. There may be some obvious results. If somebody exits the operations through a termination, you'll know there was, those witnesses will obviously know. But witnesses, besides the human curiosity factor, there is often increased responsibility and guilt, if you like, from the witnesses if they think they're responsible for someone's termination. And I just wouldn't put that on those witnesses. And that's, you know, one of the things I say to witnesses is, you may not know the outcome or the ultimate discipline that results from this if you're the witness. We're doing that to respect everybody's privacy. We are also doing that to make sure that you know, we not only respect people's privacy but the process. There's just some information that just can be disruptive, and if they have any particular concerns about that, to talk to you about it. So you're communicating information on a need-to-know basis. The complainant, if there is one, has a need to know that the investigation was concluded, what the results were. You may find that as a result of your investigation there's some discipline imposed. They might not be fired, for example, but you might have a letter on file, or you might be doing some discipline. It's nobody else's business other than that person affected and people you're reporting to, of course, what that discipline was. So the curious or the witnesses, and sometimes the complainant will want to know specifics, and they don't even necessarily have the right to do that. So let me give you an example. In a case of a complaint of harassment, the person making the complaint, we found that as a result of the investigation, some of the facts that were alleged did happen, weren't serious enough to discharge the person. So the person that was the wrongdoer, the accused, if you like, had a disciplinary letter and some terms and some supervision and performance management things worked into that person's, that the supervisor was going to be working with that employee on. The person who laid the complaint to begin with doesn't necessarily have the right to know all of those details, because some of that performance management, if you like, can be very personal, you know, in terms of between the supervisor or the employer and that employee. Suffice to say that the person who raises the complaint gets to know, we didn't find evidence that supported this complaint. We did find that certain things happened that wasn't appropriate. We have taken appropriate discipline, and I'm sorry we can't tell you what the details of those were. Again, you're playing it. It's, you know, there's no one size fits all on what gets disclosed and what doesn't get disclosed, but you are trying to balance assuring the person who laid the complaint that a good due process was done with the privacy and the ability to manage your operations in a fair way, where, again, the post-investigation gossip or the revenge discussions don't continue on and undermine your operations or your business. The witnesses, it goes with, you know, again, there's so many of these things, which is why these slides should help you with as a checklist, and I won't go through them all, but confidentiality, do emphasize with your witnesses that it's really important not to be talking about this, the investigation afterwards, and outside or after the interview. You always want to, if you've come to a conclusion and somebody that has been accused of some wrongdoing, you want to present that to them. Don't just surprise them with a termination letter. It's always a good idea to say, we've done our investigation, we've come to this conclusion, and our decision is this. You're not getting into lots of the details, but it's sufficiently so this person understands the basis for the decision. This slide here talks about punishment should fit the crime, and although we're not talking typically about true criminal proceedings, it is important that any discipline that you mete out to employees is reflective of the actual incident and the seriousness. Was it a single incident? Was there pre-warnings or training on this particular issue? Those were, and not to mention, the service of the person. Is this a 23-year service person with a spotless performance record, or is it somebody with shorter service who's been a problem child for you for years? That will affect certainly your discipline if it's relevant, but make sure it doesn't affect your attitude or prejudging the person with respect to this particular incident. It's very tempting to, if you have a problem child, and there's many of them in the workplace, as you know, who is consistently on the radar for various issues. If they get embroiled in one of these incidents that you're investigating, it's so easy to say, well, of course they did it, or, you know, of course we're going to do this. But once in a while, they actually didn't. And once in a while, you know, the so-called punishment may be a little bit overboard, given that maybe some of the other things that this person was involved in was completely unrelated. So try to keep an open mind. And if in doubt, that's really is a good time to get some external advice, or go to within your organization, somebody completely unremoved, relay the facts, relay the results of the investigation, and say, you know, what would you do in this situation? Somebody that you respect, and that's really a good test, you know, to see how objective your results are. Sometimes the investigations may find that, you know, when you're considering the possibilities of a response, that yes, this person did it, but there really were some flaws in your policy, or there really were some flaws in the training, or you had a supervisor who was condoning things to the point where they got a little bit out of control. Those are all what I would call mitigating factors with respect to a response to a particular individual, but they will definitely identify the other steps that you're going to want to take, again, for risk management reasons. It is true, and it's no surprise to you, I'm sure, that managerial staff are held to a higher standard than non-managers. They're expected to have a broader perspective about things, and so you typically would take a harsher response to somebody in a level of authority than you would somebody who is not. So taking action is sometimes a hard part for employers. I have known clients who knew the results of an investigation, knew and just procrastinated with respect to doing something about it because it's hard. And there is no question that if it's a termination, or if it's a reshuffling or reorganizing a department to take out a troublesome individual, or a non-performing manager, those are not easy things to do. And in the hurly-burly of running your business, it's easier to do the things that you know and you're comfortable with doing, and the things that generate revenue than dealing with some of these things. But the longer you put off a decision, or procrastinate, for lack of a better word, the more difficult it will be to support that kind of a decision, because it's like you're condoning it. It's like, well, this was really serious, but we didn't do anything for 6 months. I had a client last week who talked about some behavior that was outrageous, that's been happening for 3 years. And so the next question is, well, what have you ever said to this person about this behavior? Clearly this person by now is thinking that this is okay. And so again, managers like to run businesses. There's lots of things they're accountable for, but in my experience, dealing with the hard people issues are hard, and there are a number of people that will just put that off. Now, in terms of creating or a remedy that is short of I'm use firing as an example, demotions or moving people to a different a different part of the organization, you do need to be mindful of constructive dismissal concerns. So constructive dismissal, in a nutshell, is you're unilaterally making a material change to somebody's employment, and that person, if it's so material and that person disagrees, they could quit and claim that they've been wrongfully terminated. So there are ways you can demote, you can move people around, make a material change. Usually it's a little bit of leverage by, gee, the result of our investigation is X, Y, and Z. We can either do this, and sometimes it's firing, or manage your performance and you're going to do this, 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 and this, or we can move you here, or that's the sort of the tough love conversation, if you like, where people, if you judge it appropriately, they may choose to continue working than to be unemployed. There's also another way to approach it, which is, gee, George, we just don't think you're going to be successful here. This investigation has outlined some challenges that you have in a certain area. We want you to be successful. We value your service. We think you could be really good at this. This is what we propose. And there are lots of employees who struggle, who know they're struggling. Most people want to be successful, and an opportunity to move somewhere else where they can be successful is often something that will be welcomed, with or without a pay adjustment in terms of compensation. If you have external counsel, or if you have internal counsel with the capacity for on the employment law side, there are some creative things you can think about in terms of grandfathering a salary for a particular time, or benefits. Creating a position where the title looks like it's somewhat similar, so that they're not facing, it's not obvious they've been demoted, for example, but maybe don't have an organization as large as they used to have. So again, you want to manage maybe the optics around the workplace, so it makes it more attractive perhaps for somebody to stay in a different position. Don't terminate in haste, goes without saying. And there is a concern about having, once you've wrapped up your investigation, you've come to a result, you have made your decision, it's still important to maintain confidentiality. So even if somebody has been terminated and they're off, you don't want management, supervisors, people involved in the investigation chatting about the facts. It's distracting, takes away from their work. It can be very bad for your organization, for morale, for example. You want to move on in a positive way, and so there's many reasons why you don't want to be having the chatter continue about this event after the fact. As I mentioned earlier, it's really important to keep a written record of your investigation. The complaint details summaries of your interviews that you did, your findings, conclusion, and the action taken. Put that in a secure place wherever you keep documents that you want to preserve. We have a new limitation act in BC for a few years now, where you have a 2-year limitation period for wrongful dismissal suits. If you are not a unionized member, it used to be 6 years, so that limitation period's come down, but you want to at least preserve it for that. There may be other statutory reasons why you want to keep your investigation results handy. One of the things that can come out of an investigation, besides the result of yes, it happened, no, it didn't happen, is opportunities to manage risk and prevent things that from happening again. As in-house counsel, one of your primary responsibilities, I would say, is managing risk and looking for things opportunistically as opposed to after the fact. And that's one of the valuable things about an organization having in-house counsel is hopefully you have some opportunities to be more proactive than reactive. I know certainly when I was in-house counsel, I much preferred the proactive approach than dealing with disasters after the fact. And so, it may provide opportunities to identify that policies need to be updated or improved, that there are other safety or other measures that need to be implemented to prevent future occurrences. And even if you thought you had an excellent policy and you have excellent safety procedures or whatever, or environmental issues, whatever it is you thought was good, now that you had an incident, it usually will identify ways to improve. And that's, there will always be the rogue employee who completely forgets the training they've had and completely forgets the policy and acts on their own. But by and large, there's often an opportunity to improve. And I certainly think you want to take that, because if you think about some of the various statutes that talk about due diligence, in what may have constituted due diligence in January may no longer be due diligence in March, once you've had a big incident in February and found out that, gee, there really was a way for that effluent to get into the river that you thought was foolproof, and now maybe we better deal with that. You want to look at opportunities to increase or refresh training, for example, and putting other kinds of preventative steps in place. There's also a good opportunity to look at your investigation process. There's, if the investigation went well, why did it go well? You want to remember that. If it didn't go so well, again, there's learnings from that usually. And sometimes, you will get information in an investigation that wasn't part of the core focus, again, that you can use for risk management or identifying areas for improvement. And the employee evaluations, for example, is one of my, comes up frequently in my investigations. You're doing something where somebody really is a problem child, and the they might have had good forms and good processes 10 years ago for employee evaluations, but it's fallen by the wayside, for example. Things like that sometimes come up in investigations. And there is certainly, in terms of after investigation, sometimes if you have a public who, if you've got a reputational issue, for example, where something that occurred did come to the attention of your customers or your clients or your or the business at large, is there some communications or some strategy that you want to take as a result of this investigation to to shore that up, to reestablish some of those relationships or credibility. That is the presentation. As I say, it was a whirlwind through the materials, and we've got a little bit of time. I probably went a little bit faster than I needed to, but in terms of investigations, they really are, if you get the planning done, if you do the planning really well, that is in my view, is one of the most important things when starting out investigation. Don't launch into it until you've got all these factors that we've identified covered, because you will get to a better place, a better result, and manage all of the other peripheral things that will happen along the way. And if there are any questions?
Nicole, I just had a question with respect to when you're talking about the discipline and the things that you can do with the offending employee, for the lack of a better term. One of the things that you mentioned was moving them to a different area or moving them to a different department. Obviously, that depends on the scope and of the employee and the value of the employee to the company, I would think. But what do you do when the employee just sort of sneaks around the back and keeps going on, or starts a new problem in the new area? I mean, do you have to reinvestigate, or can you just take more corrective action at that point?
Well, I guess it depends on how good.
Can you just repeat
Yeah,
the question?
sorry. The question was, if you have, as a result of an investigation, moved somebody to a different department, but that behavior continues, do you start the investigation over again? And I think the answer is, I hate doing this as a lawyer, it depends. but it truly does depend on how good your information is. I mean, presumably when this person was moved, you were pretty clear about expectations, both what they are going to do or supposed to do and what they're supposed to not to do. And if you have some evidence of that, you can usually more summarily terminate, for example. There's a tool that we use sometimes they're called last chance agreements, or they can be a true agreement where somebody says, well, in consideration of you keeping your job, you're going to do X, Y, and Z, and be very tight on those X, Y, and Zs. And if any of these things happen, we can terminate you. That's the idea of a last chance agreement. Or if it's unilateral, you've put somebody on very clear notice, this is what we expect, and if this happens again, we will terminate or take these consequences. So you're very clear at the outset. Hopefully that prevents this reoccurrence, but you don't want it to get to a point where it's out of, where you need that full-blown investigation. But particularly in harassment cases, I've found where it's not, as you say, it's a little bit, it's not on the surface, but it's just an underlying troublemaker. Sometimes the warning is, if I hear of any, if we hear of some interpersonal issues like this and this, we're going to be, we're going to be investigating that. And if we find that you're at the center of it, that's it. So that's sort of how I would long-winded answer to the question. Another question?
I'm wondering, when do you advise the person who's the subject of the complaint, that they're under investigation, and give them an opportunity to tell their story? Because I've seen it where the person who's the subject of the complaint is notified at the end of the process, which to them, I assume, feels like, what can I do at this point? The investigation is complete, my input is useless. And on the other hand, you can't have them at the beginning, because I assume that would also create evidentiary problems and additional harassment. So when do you engage them in their opportunity to tell their story?
Okay, so the question was, when do you let somebody who is the core of an investigation, the accused, if you like, know about the investigation and what they're being accused of? And it's another one of those depends questions, because it really does depend on where you're going to get that evidence from. Because it is true that there are some things you may want to look into before anyone knows what's going on, just in case somebody has the ability to cover their tracks. So what kind of offense is it that you're investigating? Secondly, there's some confidentiality and privacy issues. If you're going to be investigating somebody's behavior and you're going to be calling witnesses in, it's probably a good idea to let the accused know that, because they're going to find out there was an investigation, for example. Or you may have some witnesses who are very nervous and they want to know, well, is this supervisor still going to be supervising me that I've just made a complaint of harassment about? And so there will be things that you need to do to mitigate the fallout, if you like, of an investigation, no matter how carefully that you've done it. So to use the example of a harassment complaint, say there's a worker who's made a harassment complaint against their supervisor. One of the things that we often will do is, if you're going to start your investigation, probably some really preliminary ones with some outside, other managers. Have you seen any of this behavior, just to get a sense of whether or not that there's some seriousness or truth to this complaint. And that doesn't take long. But if you think, yes, this deserves a full-fledged investigation, usually you're going to have to tell the supervisor pretty early on that there's been a complaint made. You may not be saying who the complainant is, but you certainly will want to make sure that they know, especially if you need to get them out of that work site. You have to give them a reason for that. And sometimes it's a paid leave. Sometimes it's a transfer to a different department. So they've got to have some information to understand that. And they will also be very curious and very concerned about the fairness of the investigation, to the point about, if you find out too far in at the end and you find out that everybody has been interviewed and they all know about it and it's just a done deal, you want to again assure that person that the process is or will be fair, and they will have an opportunity to be heard. They will have an opportunity to address all of the information that comes out of the investigation, and that one of their responsibilities at the moment is to carry on with their work and not talk about it. So you're managing the information flow, you're managing expectations, and you're managing the situation as best you can, and there's no one size fits all, I'm afraid. Is there any other questions? Hearing none, I'd like to thank you very much for attending. This if I don't say this, Anne will club me afterwards. This seminar does qualify as an hour of CPD credits for you. When you go onto the Law Society website, if you just look for Miller Thomson as one of the providers, you can usually find it by date or by topic, and you'll be able to click onto it to get the credits for that. So thanks very much. Again, if you have any questions that come to you otherwise, whether you're online or in person, you've got our contact information in the materials, and any of us would be more than happy to answer. Thanks.